In today's video, I'm going to talk about the Military Lending Act. Hi, this is Consumer Protection Attorney Bill Clanton. I've helped hundreds of consumers deal with inaccurate credit reporting, debt collection harassment, and other consumer-related matters, and especially our service members. Now, today I'm going to talk about the Military Lending Act. And first, I want to talk about how it's different from the Servicemembers Civil Relief Act. The Servicemembers Civil Relief Act covers a lot of areas, but it specifically has an interest rate cap and some requirements when a service member is sued. Now, the interest rate cap for service members under the SCRA is for loans that were taken out or debts that occurred before entering military service. After you enter military service, the cap on the interest rate on those debts is 6%. You can write a letter into the SCRA and have your interest rates reduced or have the extra interest you paid reimbursed. Now, the Military Lending Act was enacted in 2006 by the Department of Defense, protects active military members and their dependents from certain lending practices that could be a risk to family members or a threat to military readiness and retention. So it's different than the SCRA. This covers debts that occur while you are in the military. It provides optional safe harbor from liability for certain procedures that creditors may use in connection with identifying covered borrowers. That's a mouthful. It means they have to be careful when they try to find you. Requires creditors to provide written disclosures plus those required by TILA. So the Truth in Lending Act, if you've ever bought a car or entered into another credit agreement, you'll recognize TILA, the TILA disclosures from the box. It says annual percentage rate, the amount financed, the total of payments, and it'll have your payment schedule below that. Those are the Truth in Lending Act or TILA disclosures. There are extra disclosures that are required by the Military Lending Act that have to be given in addition to those to service members who are applying for credit. The Military Lending Act restricts loan rollovers, renewals, and refinancing by some types of creditors. The Military Lending Act also prohibits certain loan terms such as prepayment penalties. Now, prepayment penalties are generally prohibited. You generally cannot be penalized for paying early on a loan. But the Military Lending Act specifically prohibits it. Mandatory arbitration clauses. That's a big deal. Most credit card agreements you enter into, most loans you get into, will have in the very fine print, sometimes it's kind of gray instead of black, it's always very small, sometimes in the back of the paper, there's almost always an arbitration clause nowadays. Those are prohibited by the Military Lending Act. And certain unreasonable notice requirements. So all the notices they give you as a service member must be reasonable. The Military Lending Act is a powerful tool that you as a military member have in your pocket. When a creditor violates the Military Lending Act, they can be responsible for damages. If you're in the military, it's important that you make sure any debts that you incurred before you join the military, whether it's student loans, car notes, even possibly a mortgage, are under the 6% cap. And while you're in the military, if you take out credit, it's important that you get the additional notices. It's also important that there is no arbitration clause in any credit agreement that you take out. If you need help with problems under the Military Lending Act, the Servicemembers Civil Relief Act, or any other kind of consumer-related problem, we're here to help you. Give us a call. My number is at the end of this video, and thank you for watching.